very first public event, which is going to be building your survival squad. And I'm excited about this event. I think it's going to be a lot of fun. So it's tomorrow, 10 a.m. Might go longer than 10 a.m. my time, so that's noon Eastern time. So you can register for free. Go to watchyourlodge.com. And I've got some cool stuff that I'm going to be sharing with you guys. So first of all, these are my slides. So I've got the slides that are queued up. I'm going to talk about the 4 roles that are important in a survival squad, you or your family, or whether you and your friends or whatever. We're going to talk about that. Then we're also going to put together our emergency master plan, our EMP. So I put this document together with my notes, and it's just your master plan in case there's an emergency. What are you going to do, right? Do you have written instructions that are printed out, hard copies? Do you have your out-of-town contacts in there? Do you have your critical household information? Do you have emergency-specific details? Do you know how to evacuate? Do you know how to shelter in place? All the checklists, all the things. It's our emergency master plan, our EMP. And so that's what we're talking about tomorrow. And I'm super excited about it. I can't wait to get into the workshop masterclass. It's fun. So if you want to sign up, it's all free. watchyourlodge.com. Links are down in the description below. And we can't wait to see you there tomorrow. And you don't need to pay to become a member, okay? It's going to be free, and we're going to keep it live for 48 hours. So it's not going to be there forever, but come join us, and it's going into the archives. All right. And so check that out, watchyourlodge.com. Okay. Now, my friends, now it is time to get into the meat and potatoes on the day and see what is inside. DC judges reject presidential immunity for Donald Trump, and nobody's surprised about this. We all knew this was coming. Why? Because we heard during oral arguments some of the bizarre questions from the judges who were saying things like, can Trump murder everybody in Congress? And then, okay, relax, ladies. So these were the judges who were actually behind this ruling, and we're going to see what they wrote in their 57-page opinion that came out of the D.C. Circuit Court of Appeals. We're going to talk about timing, about when this trial is going to happen, if it is going to happen before the election, as Jack Smith and the Democrats really want. You know, they're freaking out to get this back on track. We're going to get reaction from Johnson and others, including Trump himself. But before we dive into the actual opinion from the judges, our friend Julie Kelly over on X at _Kelly2 on the X platform, she says, just so you're aware of who we're talking about, a lot of these judges like to hide behind their robes, their gavels, and their closed down courtrooms. But here's the people that we're talking about. The first 3 judges were appointed by Obama and Biden. Okay, so Judge Chutkan, you know her. This is the other judge who's on the bench. And this is Judge Pan, I believe, also on the bench, all appointed by Obama. And so, you know, you just kind of have, that's what they look like. Now, the other judge has been on the court for 34 years, this woman, and she was appointed by Bush, and she's actually older than all of the other Supreme Court judges who are there. And in the Supreme Court, right? So, like, been around for a long time. So they took about a month to draft this opinion. They listened to oral arguments, and they came up with their conclusion that Trump is not immune. And so we're going to go through that. We're going to jump back out and refresh our recollection. The actual question was, because in this opinion, there's going to be a lot of arguing around the point. Okay, getting around, they're going to make a lot of arguments. It's all going to sound good, but that's not what we're actually talking about here. And we've seen a lot of this with the Trump stuff, and it's pretty bad legal crafting. But I think honestly, if I can just for a second think about this, why are they doing all of this? You know, they're breaking standards. They're setting bad precedent. All of this is for a reason, right? It's to stop Trump. And I think there's this unspoken rule that's happening throughout all this litigation, especially these appeals. It's that this is not going to happen again, okay? We're not going to have another president come through our courtroom again. We're not going to lose control again. So we're going to be willing to break and bend and maneuver all of these rules, all of this precedent, because it's only for Trump. As we say here often, it's break glass in case of emergency, but we're not going to have another emergency because we're never going to lose the presidency again, okay? So they'll shatter this, and they'll say there's not going to be that many consequences to the executive branch because we're never going to be here again. But we're willing to do whatever it takes now, right now. Now, nobody's going to say that openly. Nobody's going to say that in public. But that's, you know, these are supposedly accomplished judges, right? And supposedly they're, you know, credentialed and they deserve to be where they are. But that's the only explanation for this, is they're breaking the rules because of Trump. All right, let's get into the opinion. Without any further ado, here's what it says. United States Court of Appeals, District of Columbia, Case, of course, as we know, the U.S. government, Joe Biden versus Donald Trump, using the DOJ as a political tool against his enemy via Jack Smith. It's a 57-pager. We're going to hit the highlights. We remember John Sauer, and we have a clip from him. He was the person who did the oral arguments back when they were before the court. Now, quick note on this. Those judges, those 3 judges, right? It's not the full Court of Appeals. Trump will have an opportunity to resubmit this to the full panel. It's called en banc. He could say, yeah, we're going to go to them and we're going to see if we get a different outcome. Probably not. Maybe he'll do that. Maybe he won't do that. Maybe he'll just take it right up to the Supreme Court. We don't know. But the point is, you know, these judges are supposed to stand for something, right? I mean, they're here, they're saving American democracy and all of this stuff, and they're concocting this opinion. But they don't have the courage to even sign their names to it. You'll notice that. Here's the opinion for the court, filed per curiam. It's the opinion of the court. Okay, it's just the opinion of the court. Nobody signed it. You normally see something like this. Now, it's before these judges, Henderson, Childs, and Pan. Normally, you'll see Henderson, with whom Childs and Judge Pan join, right? Or this person joins, and this person with whom this person joins, right? But they didn't even sign their names to this, right? Not even sign. It's just pure curiam, just the opinion of the court. Well, what's up with that? If you're going to be, you know, enacting historic precedent, don't you want your name behind it? Or the answer is no, right? Because they know this is not good law. They know that they are breaking glass in case of emergency. They just have to write this just to stop Trump, okay? But if this was reconcocted, if this was brought against Joe Biden or brought against Barack Obama for executing American citizens or Biden for causing an invasion at the southern border or whatever, okay, there would be a strong defense of the presidential actions. But they are, you know, it's kind of like when you stab somebody in the back, you don't want anyone to know about it. So just pure curiam. You know, we really, this is a good opinion. It's really good law, but we're just not going to sign it. So nobody knows who actually wrote it, and it's not on my record in the history books. Okay. So they write, per curiam, bunch of weenies, says Donald Trump was elected the 45th president. He was sworn into office, we know that. And his term expired on noon. Now, at that moment, they write, President Trump became former President Trump. Wow. Now, although the sequence is set by the Constitution, it did not proceed peacefully. From election day 2020 forward, the government alleges that Trump denied that he had lost his bid for a second term, and he challenged the election electoral results. There was a rally held on January 6th. The rally was headlined by Trump, and there was a breach at the Capitol. And the breach, this so-called insurrection, they even admit in this circuit court, it delayed the congressional proceedings for several hours. Wow, several hours. And it was not until the early February 7th, which was like midnight, okay, big deal. Results were certified, and Joe Biden was sworn in as the president. You know, soon to be president, confirmed. Thanks for that. Now, since then, hundreds of people who breached the Capitol have been prosecuted and imprisoned by their political enemies. And Trump was charged with a 4-count indictment as a result of his actions. Now, former Trump moved to dismiss the indictment, and so we're going to pay close attention to this. What are we talking about in this filing? It was a motion to dismiss, and the district court Judge Chutkan denied that. Today, we affirmed Chutkan's decision. Now, for the purpose of this criminal case, former President Trump has become Citizen Trump. Now, this is an interesting statement here. With all of the defenses of any other criminal defendant. But any executive immunity that may have protected him while he served as president no longer protects him against this prosecution, which is a wild thing to even to say that, because it's like actions that they're charging him with crimes over. He was the president at that time. He didn't commit a new crime. He didn't leave office in January 21st, and then go commit a new crime. In this case, the allegations are about January 6th, when he actually was the president, and he actually did have control of the government, and he did have a duty and an obligation to make sure our elections aren't rigged. So what they're acknowledging is apparently they're stripping him of that prior, and we're just saying we're taking him out. He's no longer the president, so we're not really thinking about that. Now, I want to also pay close attention to this, because what are we talking about? Yes, this is Trump's motion to dismiss, certainly. And so what standards are we applying to this? Like, what does Trump have to show the dismissal? And the basis for the dismissal, which you can add another layer to this, is immunity. Okay, so it's not motion to dismiss because of a corrupt prosecutor, like maybe we see in RICO case in Georgia, or a motion to dismiss because there's no evidence, right? They lost the blood results or something. It's a motion to dismiss because the president is immune. It's not necessarily a problem with their case, but it's that the president has immunity. And that's kind of a separate thing than a regular, just generic motion to dismiss. So how are they treating this? Are they treating this as a motion to dismiss, affirming that we've got immunity, and then applying a new immunity standard, or are we applying a motion to dismiss standard? How are we measuring? What's the measuring stick against which we are proceeding? So let's see what the court tells us. Here's the background. They say Trump did not concede 2020. His supporters made numerous attempts to challenge the results. Many attempts were allegedly criminal. Allegedly. Yeah, from Fannie. Now, a DA, a District of Columbia federal grand jury, returned an indictment. We know the 4 counts. And of course, as you'll know, let's just confirm this, not a single insurrection charge amongst them. Conspiracy to defraud the United States by overturning the election results. So a conspiracy to defraud. Another conspiracy to obstruct an official proceeding. Okay. Obstruction of the official electoral vote count. And a conspiracy against rights. Section 241, to have their votes counted. All of these were just conspiracy charges, right? And the things that they're alleging, the conduct,
I mean, if it's a conspiracy, he should be charged with other people.
Saying you tried to take away people's votes. Why was that? It was by him enforcing the rules. Saying, were those votes counted? Did you have the signatures? In other words, leading the investigation. So they're saying that all of that conduct is criminal. Now, we emphasize that whether the indictment's allegations are supported by evidence sufficient to sustain the convictions must be determined at a later stage of the production. But here is what as I backed up, and we're talking about these standards, right? Motion to dismiss the indictment. So what they're doing is they're going to say, at this stage of the prosecution, we kind of want more there. What stage? Like the motion to dismiss stage with an immunity provision. He said, we assume that the allegations set forth in the indictment are true. We're just going to presume that whatever Jack Smith said is true.
So we're going to presume guilt.
Problematic, and it could be problematic because, again, we don't really know what the standard is. Like, what's the measuring stick? We don't know. But think about it this way. Like, if someone's going to file a motion to dismiss against you, you want the benefit of saying, well, if they're going to move against me, they need to show that even if everything that I said is true, they would still win. Then you could dismiss my case. So in other words, we hold the non-moving party in a light most favorable to the non-moving party. So since Trump is moving to dismiss it, they're going to say, okay, well, let's say that everything that Trump says, everything in the indictment is true. If Trump still merits a dismissal of that benefit of the doubt, then we'll dismiss it. And immunity would actually do that, right? You can say everything Jack Smith said is true. That's fine. Trump has immunity. It's just like self-defense. It's like, yeah, I punched the dude in the face. Yeah, I broke his nose. Yeah, there's blood all over the place. I'm, not happy that he's unhappy with that. That's true. But I was privileged, right? I'm immune from charges because I was acting in self-defense. Same concept. So the indictment here alleges that Trump understood, which they're going to have a hard time proving that. I've never got that sense, that he had lost the election, but nevertheless that the results were legitimate. And he knew that the results were legitimate, but nevertheless he was determined to remain in power. He then conspired with others to cast doubt on the election outcome to contrive himself to be the winner. Now, the indictment charges that he and his co-conspirators used 5 primary means. 1, false claims of election fraud. So they said, we have an opinion that the election was rigged, and they said, you can't have that opinion. And they said that there were statements they went through. 10,000 dead voters voted in Georgia, 205,000 more votes in Pennsylvania, 30,000 non-citizens in Arizona, right? So they were, spreading misinformation about this. Second, then Trump and his co-conspirators, then they organized fraudulent slates of electors, which we've seen in prior elections, like I think 1960 back in Hawaii, when they had alternative electors. So then they caused the fraudulent electors to transmit their certificates to VP Pence, which again, you would do if you were anchoring in your party's position, right? You're saying, hey, we're going to contest this. This is our slate. It's an alternate slate from the party. We're challenging this. Third, then Trump and his co-conspirators, then they contacted DOJ officials. They said, hey, can you investigate this stuff? And they said that there were false claims that the DOJ had identified concerns. And then fourth, that they put pressure on Mike Pence to encourage him to undo it. And then was the icing of the cake, the J6 rally. So then Trump, he made efforts to overturn the Constitution, and there was an impeachment that took place. Now, 9 days before Biden's inauguration, the House adopted an impeachment resolution under Nancy Pelosi called incitement of insurrection, the same allegations that are happening here in this case. Now, the impeachment resolution, it asserted that Trump repeatedly issued false statements about the election, and they tried to impeach him on that. But he was acquitted. Now, by the time the United States conducted the trial, he had become former President Trump. Now, at the close of trial, 57 senators voted to acquit him. And because 2/3 of the Senate did not vote for conviction, he was acquitted. But they're going to say that doesn't really count. Right? They're going to say, well, some of those senators didn't vote. They voted to acquit him on other reasons, and so they all didn't have the same reason, and so we're not really going to count that. And the impeachment judgment clause doesn't apply. On November 15th, then U.S. Attorney General appointed John Smith as special counsel to investigate all this. And of course, we got an indictment after August 1st, 2023. So Trump is here now. He's saying a bunch of things. One, presidential immunity, constitutional provisions like the impeachment judgment clause and double jeopardy prevent him from being charged again. He's already tried on this in the Senate. He was already acquitted. We just gave the checkbox right here. Boom. He was acquitted on that. So how are they trying him again? On December 1st, the district court shut him, rejected all of his claims, saying that there's no way that a president could be exempt. Trump filed a number of appeals, and here we are today. Now, the court is going to give us some jurisdictional stuff, right? We'll fast forward through a lot of this. Usually this is pretty technical. They're talking about district court orders that are, basically we've got the authority to hear this case. And we'll fast forward through this. We exercise jurisdiction for a couple reasons, and we can hear this case. A lot of case law, right? They're going through Midland and other things. American oversight hinges on this. Supreme Court has distinguished that. The court ultimately here, there's not a good reason to read this way, blah, blah, blah. And so procedural rules about what they can do. So let's get to some more analysis about their background here. Now, former President Trump and his two arguments, they can be analogized to constitutional immunities, which these other cases require. Now, his separation of powers argument does not explicitly draw on speech or the debate clause like they did in those other cases, but the immunity for official acts that Trump asserts is closely akin, so they're trying to analogize this to another case, closely akin to a debate clause. So this is really the type of immunity that Trump is trying to claim. They've got this other case law where it kind of matches that. Likewise, Trump argues that the impeachment judgment clause incorporates a double jeopardy principle, right? Trump, how can you be tried twice for the same offense? And Trump was acquitted in the Senate. Now, we found a similar line of reasoning that's convincing in this case. If a treaty provision mirrors the double jeopardy clause, so does a constitutional clause that attaches jeopardy to the impeachment acquittal. Now, both of former President Trump's arguments are the least analogous, are at least analogous enough to the speech or debate clause and double jeopardy to fit within our precedent. Accordingly, we conclude, okay, this is the jurisdiction section, that we have jurisdiction to reach the merits on the appeal. So they can hear the case, fine. Now, for all immunity doctrines, the burden is on the official claiming the immunity to demonstrate the entitlement. Right now we're talking standards. Here, Trump claims absolute immunity from criminal prosecution for all official acts undertaken as president, a category he contends includes all of the conduct alleged in the indictment. So that is a little bit overbroad, isn't it? I think it is. So that's kind of not what he's saying exactly. So all official acts, well, I guess that is true. Now, the point here, they're leaving out a little parentheses, right? They're leaving out the point where the Congress has a check on this. Okay, so they like to use this talking point that Trump claims he can do this. He has absolute immunity. Well, sort of, but Congress can eliminate that, okay? Like absolute immunity subject to Congress. So it's not really absolute. I mean, it's pretty close, but if Congress impeaches you and convicts you, then that is shattered, okay? So it's not really absolute immunity. Absolute to me means nobody can take it away from you. There is a mechanism to take that away from you. Very easy. All Congress has to do is impeach you and convict you. And by the way, that is a normal process in law. Happens all the time. That you have safety proceedings to make sure that there is actually teeth there before you move with something forward. For example, before you can be indicted with a crime, they got to show probable cause. We know this, right? Before you, as a regular citizen, can be charged, a cop has to think there's cause there and write a direct complaint against you and arrest you. Or a prosecutor needs to indict the case to a grand jury and show that there is cause in order to take it to the next step. So the same thing applies to the president. And this is a political safety valve. It's a safeguard. The president needs to be impeached and convicted, and we can, by going through that process, we know it's not political because there's a 2/3 majority. Even the president's own party, his own supporters are saying, okay, this dude's a criminal. So it's not absolute immunity. So this is, I think, overbroad. They just make that the argument, and that's not the argument. It's much narrower than that because we heard that even from D. John Sauer. This is the attorney on Donald Trump's team who was arguing this very point. Question from the judge, Judge Pan. Can he execute his political opponents? Here is what Sauer said in response to this.
Your position is that he can't be prosecuted for that unless he's impeached.
That was as long as I mean, in certain cases, purely private conduct under Clinton against Jones, you'd be subject to prosecution for that as long as he's not in office, but as long as he's officially.
When the president ordered SEAL Team 6 to assassinate a political rival, that's an official act in order to SEAL Team 6.
He would have to be and would speedily be, impeached and convicted before the criminal prosecution.
But if you weren't, there would be no criminal prosecution, no criminal liability for that.
Chief Justice's opinion in Marbury against Magnuson and our Constitutional Commission and the plain language of the impeachment judgment clause all clearly presuppose that what the founders were concerned about was not.
I asked you a yes or no question. Could a president who ordered SEAL Team 6 to assassinate a political rival who was not impeached, would he be subject to criminal prosecution?
If he were impeached and convicted first.
So your answer is
yes.
No.
My answer is qualified yes. There's a political process that would have to occur under our Constitution, which require impeachment and conviction by the Senate. In these exceptional cases, as the OLC memo itself points out from the Department of Justice, you'd expect a speedy impeachment and conviction. But what the founders are much more worried about than using criminal prosecution to discipline presidents was what James Madison calls in Federalist Number 47, the newfangled and artificial treasons. They were much more concerned about the abuse of the criminal process for political purposes to disable the presidency from factions and political opponents. And of course, that's exactly what we see in this case.
So I've asked you a series of hypotheticals about criminal actions that could be taken by a president that could be considered official acts, and I've asked you, would such a president be subject to criminal prosecution if he's not impeached?
Requirement.
And your answer, your yes or no answer is no.
Yes. I said qualified yes if he's impeached and convicted first.
My question was, okay, so he's not impeached or convicted. Let's put that aside. You're saying a president could sell pardons, could sell military secrets, could order SEAL Team 6 to assassinate.
She just changed the question.
Sale of military secrets strikes me as something that might not be held to be an official act. The sale of pardons is something that's come up historically and was not.
She just changed her question.
Says that.
Okay, so she just changed her question because she didn't like his answer. So then she threw in some other stuff. So she was trying to get an answer that she wanted. She didn't like his answer. She wanted him to say no. He didn't say no, but they respond as though he said no. They claim absolute immunity. He didn't say that. He said immunity subject to impeachment. But here's where they're going to continue to just argue for points that no one's making. So they say the question of whether former President Trump enjoys absolute immunity from federal criminal liability is one of first impression. That's not his argument at all. Okay, it's a qualified immunity. Okay, it's not absolute. Noting that meaning if he gets impeached, it goes away. Noting that the unresolved question of whether or when a president might be immune from criminal prosecution. Says SCOTUS has consistently held that even a sitting president is not immune from responding to criminal subpoenas. And in the civil context, the SCOTUS has said that a former president is absolutely immune from civil liability for official acts if those are within the outer perimeter of his official responsibility. Okay, so that's civil stuff. So the president has absolute immunity from civil liability for his official acts, which is even broader than this because, arguably the impeachment judgment clause doesn't apply to that. Both sitting and former presidents remain civilly liable for private conduct, okay? And when considering the issue of presidential immunity, SCOTUS has been careful to note that its holdings on civil liability do not carry over to criminal prosecutions. Now, former President Trump, he claimed he would have us extend the framework for civil immunity to criminal cases and decide for the first time that a president is categorically immune from criminal prosecution for any act conceivably within the outer perimeter of his executive responsibility, which is true, but he's still subject to, that he could be charged, right, with impeachment. Like, they just leave that out. It irks me. He advances 3 grounds for establishing this expansive immunity. Now, here is where they finally get to it. Article 3 courts lack the power to review his official acts under the separation of powers document because they're substituting their judgment for the president's judgment. They're saying, well, you can't do that, or you can do that. But that's not their judgment. Otherwise, the courts become the president. If the courts can dictate to a president what he's allowed to do or not do, then the court is the president, right, in many ways, especially for issues that are their official acts. So they say, number 2, functional policy considerations rooted in the separation require immunity to avoid intruding on executive branch functions. And then finally, that the impeachment judgment clause does not allow the criminal prosecution in the absence of Congress impeaching him and convicting him, which was a main point of their argument that they forgot in all of these other paragraphs. Thanks for finally acknowledging it. Now, our analysis is guided by the Constitution. Yeah, right. Relying on these sources, we reject all the bases for Trump's immunity. Now, they're going to give us some background on this. All right, separation of powers, saying the Constitution is important and the president occupies a unique position, according to Judge Chepkin. Now, under the separation of powers, the president has executive power to take care that the laws be executed, which includes making sure our elections are not rigged. It's settled law, separation of powers in here. They say, nevertheless, look, Trump argues that the constitutional structure and the separation of powers means that neither a nor a state prosecutor nor a state or federal court may sit in judgment over a president's official acts because they're the president's acts alone. They can, but the mechanism in place to protect the presidency against those things has to be overcome. He relies on Marbury, but they say, sorry, Trump misreads Marbury. If you properly understood Marbury, they say the separation of powers doctrine, it may immunize lawful discretionary acts, but it does not bar the federal criminal prosecution of a former president for every official act, which again, they're not making that point. They didn't say that about Marbury. Marbury distinguished between 2 kinds of official acts, discretionary and ministerial. Chief Justice recognized a lot of this, a Marbury case law here. And then in Mississippi, there was some more law. Then the Supreme Court exercised some stuff over steel mills. Now, objections were made in the Marbury, and the Supreme Court has repeatedly affirmed that the judiciary has the power to direct appropriate process to the president. But the president does not enjoy absolute immunity from criminal subpoenas. We have that case that supported that one. And so the separation of powers doctrine, in summarizing all of this, as expounded and its progeny from Marbury that they just educated us about, it necessarily permits the judiciary to oversee the federal criminal prosecution of a former president for his official acts, because the fact of the prosecution means that the former president has allegedly acted in defiance of Congress's laws. Now, although certain discretionary actions may be insulated from judicial review, they say is that the president violated Congress's laws, then I guess that pulls him out. That's all you need. Here we finally get some application to the actual case. Here, former President Trump's actions allegedly violated generally applicable criminal laws, meaning those acts were not within the scope of his lawful discretion. And so, therefore, Marbury and its progeny provide him no structural immunity